This is the case of Brian Hyden versus Metal Technologies of Indiana, doing business as Metal Technologies and Dock Foundry, 19935NO. And Ms. Rothus is here on behalf of the plaintiff, and Mr. Wagner is here on behalf of the defendant. And this is a renotice of a motion to compel discovery that was filed by Mr. Wagner. And I reviewed the file, and Mr. Wagner, go ahead.
Your Honor, there's actually two motions. Motion to strike the fourth witness list, which is a more important motion, I think. So I'll take that first unless the court has a preference.
No, go ahead.
This is a situation, Your Honor, and this is going to be the first of a series of motions that I think the court will soon get. But trying to get discovery accomplished in this matter has been difficult, and this is one of the examples. But on June 4th, 2020, on behalf of Metal Technologies, I sent or served discoveries that included expert interrogatories and requests to produce to Ms. Rothus. The responses were delayed, but when I ultimately got the responses, her answer to my request to identify her experts was experts at present include treating doctors. I do not have their background information at the moment. September 17th, 2020, on behalf of Dock Foundries, served the identical set, and I got the exact same response. She has never supplemented her discovery or expert discovery responses. Late in March of 2021, Ms. Rothus calls me on the telephone, and she tells me that her expert, Dr. Ansel, has passed away, and requested that I agree to extend the date to name expert witnesses versus her having to file a motion with the court. And we had an extended conversation about that, some of which will be relevant here today. But ultimately, I said it'd be foolish of me to force you to file a motion, because if I was Judge Stutesman, I would, how do I tell somebody whose experts died that they can't replace that expert? That would be nonsense. And so I agreed to a stipulation. There were a couple formats of that were sent to me from Ms. Rothus, and my concern was expressed to her was, I need you to identify these people on a certain date so I can do whatever discovery I need to do before that discovery cutoff date comes. So we agreed on April 23rd, 2021. So the date would be moved from November 4th, 2020, which had already passed, to April 23rd, 2021. Ms. Rothus did not file the witness list until May 5th, 2021. That's the Fourth Amendment witness list. At that time, she not only replaced Dr. Ansel, which I had agreed to, she added two new experts who had not previously been disclosed to me in any manner whatsoever. An Emily Escott, apparently a neuropsychology expert, and a Paul, I'm not sure if I pronounced that name correctly, Zumda, S-Z-U-M-D-A, who's identified as a functional capacity evaluator. What's interesting about both of those, then I subsequently received on May 19th, 2021, a functional evaluation report from this Paul Zumda, which had a evaluation date of April 15th, 2021, before the witness list was due. On May 23rd, 2021, I received a report from this Emily Escott, which had an evaluation date of April 14th, 2021. To date, I have not received any type of report nor updated answers to discovery identifying what this Elizabeth Paskikowski, who is a vocational rehabilitation expert, is going to testify to. That is the expert who's, my understanding, is going to replace Dr. Ansel. Nothing on that. So the conversation concerned Dr. Ansel, vocational rehabilitation expert, I assume because I have a vocational rehabilitation expert, nothing on that. This was clearly just an effort to get in two unidentified experts, and they were identified to me late. I would note as an aside, because this is obviously going to be a very pressing issue to me, I was forced to take Mr. Hyden's deposition by Zoom, despite Ms. Roth's taking my clients' employees' depositions in person. And if I'm reading these expert reports correctly, not only was Mr. Hyden able to travel from Tennessee to Michigan to meet with these individuals, he met with them live. Should be a note that my vocational rehabilitation expert could only speak to Mr. Hyden through a Zoom interview, not in person. There are difficulties with working with Zoom that necessitates in-person conversations, depositions, interviews, I believe, and I believe my experts will support that. So discovery closes next month. I'm in a situation where I've prepared my case based on the understanding that she's going to rely upon treating doctors. And now I'm getting a series of undisclosed, late disclosed, retained experts who I have to now attempt to prepare against. My doctors are not prepared to defend against this. A coming motion will be Dr. Collis, who's a retained expert, who we just deposed in response to a subpoena, provided, I would say, a very minimal amount of records during a deposition. All of a sudden, he apparently had, I would roughly estimate, thousands of documents upon which he had been reviewed, which were absolutely not disclosed to me. That is the situation I'm in. That is why this motion has been filed. I'm asking the court to strike that fourth amendment witness list, and we can proceed according to her discovery responses that she's going to rely upon her treating doctors, and we can get this case moving. I can answer any questions, Your Honor, but that's it in a nutshell.
Just to clarify, you say the evaluations were done in April, but does it have a report date as to when it was sent out?
Let me check real quick. I have, was sent to me, let me see, the date of the report for...
Not when it was sent to you, when did they write the report, I guess? You said they were evaluated in April. I'm curious as to when the experts then wrote the report.
I'm looking at Dr. Escott's report. It says data report 4/30/21. And then it was apparently sent to me. The cover letter from Ms. Roth was May 13th, 2021. And then the functional evaluation, let's see here. I don't see a date, Your Honor, other than the date of the evaluation.
Okay. All right. So it was done late. All right. So Ms. Rothus, go ahead.
You know, Your Honor, that statement of Mr. Wagner's was full of half things that were not true. I searched my file, which is huge on this case. This is a very work-intensive case. Mr. Wagner, I don't have any expert interrogatories from you in my file. This is not an e-file case. Everything's got to come mail. I'm not saying he didn't send them, but the mail is horrible during COVID. I do not have expert interrogatories. So I diligently amended my witness list, and yes, I had a death of a vocational expert. That's not easy. That is a plaintiff expert that we've used for 30, 40, 50 years. The man was in his 80s. We had to search around and find other replacements. I had to talk.
But he's not talking about Mr. Anselm. He recognized that one. He's talking about this late disclosure of yet more experts. And so here, okay, we're in a new time, all right? And we're getting back to the normal time. And so what his complaint is that, You know, he's doing work, he's taking depositions, he's billing his client for work, and then you're adding things on that he's gonna have to go back and do over again. And it's probably the same with you. I mean, you're spending time on things and then submitting reports. The idea of discovery is both sides know what the other side has. The idea of discovery is that there's no surprises at trial and nothing's gonna come out and nothing's gonna do anything. Mr. Wagner, I appreciate your motion to strike and the need for it, but as you said, I have to issue the order to compel them to do anything before I can take a drastic measure like dismiss or strike witnesses.
Yeah.
Or else it's just going to come back to me again for an abuse of discretion. But you are right. I want these motions brought promptly. If the time has passed on a motion to compel and you've done the request as you should between each other, and you still don't get an answer, then bring it to my attention so I can issue the order to compel. Now, this is a different issue because the order to compel, it was answered late. I'm going to give you both additional discovery, and because I don't have a trial date right now for you. I was telling the other people that were up this morning, right now, cases that are ready for trial, that they were ready for trial before we shut down, and they were just waiting for their trial date. Now I'm putting them in trial slots, but I'm already through Christmas with those. Those that are still doing discovery, you have time to do more discovery, but at the same time, it's not fair to one side to continually drip and drab evidence and take depositions that are going to be changed by the prior testimony.
Your Honor, can I say something? Because Mr. Wagner's made several misrepresentations. He never asked to see my client in person for anything, not an exam, not a deposition. He made his choices, he did them, and I made my choices, and my client came for the exams in person. Mr. Wagner never approached me and asked me for in-person depositions. Furthermore, Mr. Wagner amended his witness list before this prior extension. He amended his witness list 4 times after the witness list date. Okay, and discovery is wide open. My reading of the case law says if discovery is wide open and you need to keep amending your witness list, you amend it. I see no prejudice on my side. I understand that Mr. Wagner took steps early on in the case of discovery, but that doesn't mean I did anything wrong. Discovery's wide open. I had to realign experts. No, discovery's open until June 23rd.
Well, my point, I'm laughing because every time you file an amended witness list, he's going to file an amended witness list to answer your witness list. So, yeah, I mean, until you're done amending, and at some point, you as plaintiff have to say, this is it. This is what I have. This is all I have. I'm not going to keep adding more to it. Yeah. So, long story short, I appreciate it, but how long do you need to get to the point where you're done? And I mean, this case is now 2 years old. I assume that you're ready to go. Yeah, and there has to be a drop dead date here for no more experts. There are clearly no more fact witnesses that are going to come up unless something happens to them that changes stuff. But so, Ms. Rothis, how long do you need to get it? Are you satisfied with what you've disclosed with this last amendment?
I am, unless the case changes in response to my witness list on Mr. Wagner's side. I'm awaiting the report. Now, this is the other thing. Yes, the exams were done within discovery, but it took a month to get my reports from the experts. Mr. Wagner gave you some dates. Both of those examinations of Mr. Hyden were done within the discovery period, but I didn't get the reports till weeks or a month later. So
that's why I asked when they were dated. So that's why I asked that. So yes, I understand.
That. Yes.
So
and I have to make one other clarification. I know what you're getting at, but I have to make one other clarification. I've given Mr. Wagner, contrary to his presentation to you, the CVs of 2 of my treating doctors and timely reports and depositions there. So his representations were not exactly on point. I've participated in 14 depositions. My client showed up timely for his deposition. He's done discovery, probably 50 authorizations. So this is a case we actually are working our best at to keep moving. It's a very work-intensive case. I got an out-of-client plaintiff. You know what I'm saying? It's very, and I've got COVID. I've got a child upstairs that didn't go back to school till mid-March. So-
Okay, Ms. Rothus,
Yeah.
let's slow down, okay?
Okay.
So,
Yeah.
I'm gonna do what Judge Lamb used to do to me 20 years ago, which is, I'm gonna put you two in a room together, and you're gonna talk to each other as to what it is you need, Mr. Wagner, from her, and she's gonna indicate what she needs from you. And then we're gonna come back in and we're gonna have an understanding, we're gonna put it on the record as to dates and times and everything that's gonna be done, so that we don't have to come back yet again. And then also, you clearly can redepose the plaintiff in light of the new experts' opinions and question them about that. And you can do whatever material you need. So you have all the time you need in the world to get your discovery done. Not all the time, I'm being facetious there. I mean, you have months to get more discovery done. But the first thing is, there's no more disclosures of any additional witnesses. I need that date, and I need to know what it is that you're waiting on, because apparently she says she didn't get some things, and that's it. And so then I'll come back and we'll put it all on the record, and then we'll do that. So I'm gonna stop with you. I'm gonna take my criminal case. I'm gonna put you two into a breakout room. You can talk, and then I'm gonna